who's going to kind of walk through.
We are live.
Good morning. This is a joint hearing of the Senate Judiciary and the Senate Health and Welfare Committee regarding S89, the Forensic Facility Bill. And Katie McKinn is going to walk through the changes. The Health and Welfare Committee is in their committee room, and we're in this committee, in the Judiciary Committee room. And through the power of technology, we're going to try to get through this. So if there's questions in the other room, just yell by these, or put up your hand. But I don't know if we'll notice. But Katie, if you can walk, can you see Katie all right?
Yes, we're fine. Thank you.
Okay,
Okay, good morning. Katie McLean, Office of Legislative Counsel. So you are receiving S89 back from the House. To refresh your memory, S89 is the bill on the forensic facility, and it created, when it left the Senate, the facility is designed to open, right now the plan is July 1, 2024. It is designed to be for individuals with intellectual disability or mental health crisis. These are individuals who are coming through the criminal justice system. So these are individuals who are civilly committed. These are individuals who are coming through that criminal door, either incompetent to stand trial or deemed not guilty by reason of insanity, and their underlying crime likely has some degree of violence that makes them a candidate for placement at a forensic facility. And to refresh your memory, a forensic facility is a new type of program that the state doesn't currently have right now. The conversations have been about using one of the units at the Vermont Psychiatric Care Hospital to house the forensic facility for the time being. The language as it left the Senate it had all of the mechanisms for commitment. So it amended all of the laws that would allow somebody to be committed to the commissioners of mental health or of jail and to be placed in a forensic facility. It had the language for involuntary medication if the individual was in the custody of the Department of Mental Health. And it had language for continued commitment. You had a rulemaking section that asked DMH and Dale to provide admissions criteria and admissions processes and set that out in rule. So the version that you're receiving back is different than the version that you sent out. There was a lot of conversation upstairs on this bill. It was only formally in House Judiciary, but House Healthcare Committee and House Human Services took some testimony on the bill as well. House Healthcare has jurisdiction over individuals or over the mental health system. Human Services has jurisdiction over individuals with intellectual disabilities, so that they were interested in the aspect pertaining to Dale. And ultimately, where this bill landed was that the Healthcare Committee was favorable in their review of the forensic facility. However, when the Human Services Committee was looking at this type of facility for somebody with an intellectual disability, they were interested in taking a step back and determining whether this was the correct placement for individuals with intellectual disability, and if so, doing a deeper dive on the law and the revising how commitments to the Commissioner of Disabilities, Aging, and Independent Living should be conducted. So what you're getting is a report or a working group to look at really that population of individuals with intellectual disability, whether they should be placed in a forensic facility, what that would look like, what type of protections would attach, what type of amendments to the statutes do we need to be able to do that. The concept behind the bill that's coming to you is still that a facility could be opened by July 1, 2024. This asks the two departments to go ahead and start working on rulemaking to make that happen. But in order for the facility to be able to open next July 1, 2024, the language that sort of mechanizes or makes it possible for somebody to be committed into the custody of mental health or jail for this purpose needs to be adopted. And so the idea is that it will come through next year as a package if the working group is able to settle on language that that everybody is in agreement with. So I will share my screen and I will walk you through this language. So we have a legislative intent section. It's the intent of the General Assembly that the initial forensic facility be authorized and operational beginning on July 1, 2024 in the 9-bed wing of the current Vermont Psychiatric Care Hospital. The wing is to be relicensed as a therapeutic community residence and shall provide a safe environment for both clients and staff. Any commingling of staff between the psychiatric hospital wing and the forensic facility shall be consistent with the requirements of any applicable collective bargaining agreements. So you'll see that this concept of which facility is being used and by what date is still consistent with the Senate version. There was language in the version of the bill that went over to the House that for forensic facilities, there was no need to have a CON. This language that's coming back to you is narrowed, and it's basically saying with regard to the 9-bed facility that we're sort of thinking about right now within the Vermont Psychiatric Care Hospital, the CON is waived, but that doesn't waive the CON for a potential future forensic facility at a different location.
Okay.
As I said, there is still rulemaking language. So by August 1st of this year, you are directing the Commissioner of Health to initiate rulemaking to amend the Department of Health rules on non-emergency and voluntary psychiatric medications for the purpose of allowing the administration of involuntary medication at a forensic facility. And then by September 1st of this year, the two commissioners are to begin drafting proposed amendments to the therapeutic community residence rules for the purpose of creating a forensic facility section within that rule that includes allowing the use of emergency and voluntary procedures, meaning seclusion or restraint, restraint being physical restraint or chemical restraint, and the administration of involuntary medication. Section 4 is a presentation.
Before we go to section 4, so they basically kept our concept of the administration developing the rules. The rules will be adopted by the joint rules committee, or has that changed? Because that was our position, was that admissions would be by rule.
That has changed. The whole admissions issue is not really addressed here.
And that's unfortunate. That is problematic. Does that mean that we would have to develop?
It would, well, next year, were you to come back and continue to move this, it would either be part of the statute as, you know, integrated into the green books, or you would have a rulemaking language at that time.
My concern is that this committee, and I believe the Health and Welfare Committee, both believe strongly that you did not want admissions to be based upon an individual judge or an individual state's attorney out in the field, because you have such divergent systems of justice county by county, and that it would be better if the department controlled it through rule as to who would be eligible. What we don't want to see is somebody who's a pain in the neck in Brattleboro ending up in the forensic facility when that's not what it's needed for. It's a limited number of people, but rather somebody who's committed a very serious crime and is found either incompetent or not guilty by reason of insanity being in the forensic facility. So that, I guess what I'm going to request, if Senator Lyons or anybody else wants to join me, is a drafting.
Dick, I guess Senator Sears, I think the question is under the current rules, they're amending current rules. So My question is, are there admissions criteria in the current rules? And
No.
I think, is there anyone here who can answer that?
Katie?
Yeah, I can answer that. So this takes a step back, this version of the bill, and it does not have admission criteria. It also doesn't have any of the language to commit somebody to a forensic facility. So in order to be able to commit somebody to a forensic facility at all, you will need legislation next year.
Okay.
And how you address the admissions issue, whether it's by statute or rule, you know, is something that could be addressed.
I believe Karen Barber has her hand up.
Thank you. Good morning. For the record, Karen Barber, General Counsel for the Department of Mental Health. Thank you, Senator Sears. We, of course, agree with you in terms of wanting to make sure there's clear criteria. When it got over to the House, what we did was work on negotiated statutory criteria so that it would be in statute as opposed to rule, just because we thought it would be a quicker process. But having clear criteria laid out in statute so that someone couldn't just admit someone to the criteria to the facility, that it was really clear under what situations the department having final say over who would get admitted, what criteria the departments were looking at. So if that addresses some of your concerns, we did work on that language.
So, sorry, but just a quick question. There will be recommendations for legislative language then, statutory language, forthcoming from the department with regard to admissions criteria?
Yes, so DMH and Dale both worked on language with the state's attorneys that I think we had agreement on in terms of the language. I think the House Judiciary agreed with the DMH portion of the language. I think where there was some hang up was on the Dale portion. What we expect is to submit to you the same language that has already been negotiated and kind of agreed to on the House side next year.
There's nothing in this bill then that asks for that language, but it will certainly be expecting it.
Yes, absolutely. We'll need that. As Katie mentioned, all of the kind of mechanisms that would actually kind of allow us to use the facility, we anticipate being passed next year because we wouldn't actually really need them this year. What we needed this year was the authority to begin the rulemaking process and to start planning for the facility.
I still would be more comfortable introducing a bill and we can circulate it to the Health and Welfare and Judiciary Committee members if they want to sign on to it. But I'm putting in a drafting request for a bill this year that would be more like what we passed in S89 this year. Because I really am worried that number one, we're delaying having the forensic facility available. And then if we get stuck in admissions, we're delaying it even further. And that's my concern with this. If we do the admissions early next year, maybe we can get something up and running in a year. But otherwise, we're going to be stuck 3 or 4 years down the road before this even takes place. Anyway, if you want to continue on, Katie. And
sure. And I will put a draft request in for you. Okay. So section 4 is a presentation. This is language mostly that welfare added to the bill, and it hasn't been changed a whole lot on the House side. So by February 1st of this coming year, AHS is to present the following information to the various policy committees: a plan for staffing and programming at the forensic facility, including whether any specialized training will be required for staff members and whether any services provided at the forensic facility will be contracted to third parties, whether any additional resources are needed for the operation of the forensic facility, an assessment of laws, regulations, rules, and policies governing psychiatric hospitals and therapeutic community residences to determine whether there are any conflicts with serving two populations in the same facility. So that subdivision 3 is new, and there was a concern that having one wing of the Vermont Psychiatric Care Hospital licensed as a therapeutic residence and the other wings licensed as a hospital. There were questions about whether there's any conflict there. So the departments would address that when they gave this presentation.
I asked one question about that. Why February 1st, 2024? Why not? Usually things would come December 15th, 2023, January 1st.
Yeah, so this is a presentation, not a report. So I think the idea is to give folks a chance to sort of meet and get their feet under them next year.
All right, well, I would prefer some other date, but if we try to change this now, we have to send it back to them, send it over, back. They've really got us by doing these things at the end of the session last week. We are unable to respond to many of their changes. Is the DMH comfortable with February 1st?
Karen Barber for the record. Yes, again, we don't anticipate there being any issues. There was a lot of testimony and House corrections. I know they had some concerns about the IMD exclusion. That's not something DMH is very concerned about. So the time frame is okay with us.
That's fine. Yeah. If you run into Marutha Norris,
I think St. Louis said.
Okay. So that brings us to section 5. This is a reporting requirement that annually on January 15th between the years of 2025 and 2030, the two departments would submit a report to the various policy committees containing the average daily census at the forensic facility, including trends over time, the number of individuals waitlisted for the forensic facility and where these individuals receive treatment or programming while waiting for a bed at the forensic facility, aggregated demographic data about the individuals served at the forensic facility, and an account of the number and types of emergency and voluntary procedures used at the forensic facility. And I believe this is all language from Senate Health and Welfare. I'm trying to recall, but I don't think that has changed. What has changed is Section 6. This is a new working group on policies pertaining to individuals with intellectual disability who are criminal justice involved. So there's created this group. The group is to assess whether a forensic level of care is needed for individuals with intellectual disability who are charged with a crime of violence against another person, have been determined incompetent to stand trial or adjudicated not guilty by reason of insanity, and are committed to the custody of the Commissioner of Dale. If it determines that forensic level care is needed for such individuals, the group is to propose legislation establishing the process and criteria for committing individuals to a forensic facility. In developing the legislation, the working group is to refer to earlier drafts of the act discussed by the General Assembly in 2023. So the idea and the conversation was that there has been a lot of work and there has been some stakeholders coming together on language and not to start from scratch, but to build off all of the work that has already been done this year and putting together a bill for next year. So in terms of membership, we have the Disability Law Project, Developmental Disabilities Council, Green Mountain Self-Advocates, Vermont Care Partners, Vermont Crisis Intervention Network, Commissioner of Dale, Commissioner of Mental Health, 2 members of the House, serving on Judiciary and Human Services, 1 member of the Senate serving on this committee in Health and Welfare. And then in completing its duties pursuant to this section, the working group, to the extent feasible, shall consult with the following individuals: a psychologist with experience conducting competency evaluations under Act 248, individuals with
Katie? I want to just ask a question there, and it's very specific to a psychologist. It seems to be that it should be a psychiatrist or psychologist, and because I know when we had the psychiatrist who works for the Howard Center, who does a number of these for the state, she was very competent and might be helpful in this process. So was that something discussed, or was it specifically directed toward a psychologist?
Yeah, I'm glad you're bringing it up because that was actually an amendment on the floor last night that they added psychologists and psychiatrists.
Okay.
So that,
but I didn't know that.
this is sorry, this is not the official House version. I'm walking through the House Judiciary Committee report. We haven't gotten the final, but thank you for bringing that up. That was addressed.
By the way, in the
Yeah,
working
no,
group.
thank you, sorry to interrupt.
Sorry.
Gynecologist?
In the working group, there's nobody representing the victims.
There's also nobody representing the sort of racial justice perspective, which we know is rampantly not, or that individuals of color are overrepresented throughout our judicial system. So I think that would be someone we would want on there too. I don't know if it's the RDAP or Susanna.
We could put on our designee from Susanna's, as well as some, I'm beginning to think, here's my frustration. The working group is the reason, the failure of the working group to come up with any recommendation is the reason that Senator Lyons and I and others introduced the bill creating the forensic facility. This working group doesn't appear that it's gonna have any different conclusion in terms of those with intellectual disabilities. And I'm extremely concerned that we're setting ourselves up for another failure. But at least the victims of the crimes should be represented in this working group. Perhaps the state employees, and as you said, because they're the ones that, state employees are the ones that are working in the forensic unit. And also the RDAP, or what is Susanna's?
The executive director of the,
Office of Racial Equity.
yes.
Or designate.
Or designee. And who would you like for the victim perspective?
Somebody selected by the Center for Crime Victim Services. Or the head of, the executive director of the Department of, I said a department? No, the executive director of Crime Victim Services or designate.
Which one? What about Dale?
And on State Employees Association, I don't know how you.
Okay.
They're picking the leader.
Can you help with that wording?
Sure, it's usually the president of the Vermont State Employees Association or designate.
Okay. I will add those.
Stuart Sure has his hand up.
Oh, I'm sorry, David? Stuart, I'm sorry.
Good morning, Senators. Thank you. Stuart Scher, General Counsel for the Department of Disabilities, Aging and Independent Living. I don't want to jump too far ahead and steal Katie's thunder, but there is some language that we'll be getting to shortly that I believe strikes a balance between membership on the working group and that would be consulted by the working group. And this was, I believe, an effort to strike that balance. Originally, the working group was designed to have, I believe it was 19 members, which many believed was not really a workable size to achieve what we needed to. But there is some reference you'll see to, I believe, the Center for Crime Victim Services as being a party that would be consulted by the members of the working group as feasible. So I just wanted to throw that out there, and also wanted to say that we do share the frustration that that some of you have expressed this morning with the timing of this. We do wish that we had been able to move forward this session with this, but we do appreciate that there are some opposing views, and in the interest of working with the stakeholders and understanding what those are, we believe that we can achieve what we are ordered to do over the summer, get back to the legislature, and taking into account the guidance that is included in the earlier drafts of this bill as specifically addressed here.
I appreciate that. You know, Senator Lyons has a different point of view, but I think leaving those groups, those three groups we mentioned out of the working group is a mistake. And it would leave, you can be in consultation with people, it doesn't mean you listen to them. And if you're a member of the group, it means you have a voice.
Certainly. And again, this working group was designed, I believe, to address the specific issue as to whether individuals with intellectual disabilities should be included in the population eligible for placement in the
Well,
facility.
I understand that. It's a little different than the working group that failed to come to any consensus, but I'm really concerned that leaving, and maybe the Health and Welfare Committee has a different position, and that's fine. But I think the majority of this committee would be concerned about leaving those three groups out.
Well, I think you're probably on target with that, but I think the discussion will be helpful in bringing recommendations back to us, and I think it does not mean that the discussion ends. I can see that this is going to be another round of testimony and discussion in each of our committees next January.
I agree. So, is there a consensus to concur with further proposal of amendment?
I think our committee is fine with doing that. I am very disappointed that the Dale section has been relegated to a working group, because we did take a lot of testimony on that, and we felt very comfortable going forward and having Dale get some rulemaking going. So it will be, we will look forward to whatever recommendations come out in December.
Okay, so I will prepare that amendment for you.
Senator Lyons, would you like to be on that with me?
Absolutely.
Thank you. Anybody else who wants?
I'm happy to be on it.
I think the 4 members of the Judiciary Committee that are here would join, and if members of your committee would like to join, I'd appreciate it too.
The next bill.
Sure.
Yeah. So Senator Sears,
Come back from the whole committee if it's like a committee report. I have to double check on that. Okay, I have to double check. But if not, I'll put your.
you're gonna be on the next bill on this, which is looking at the admissions requirements for folks going to the forensic facility.
Okay,
There's no way we're gonna get the
I don't know, it is a continuation of the work that they're doing, and
individual.
they took things out of the bill that we had in the bill, so.
You say on the bill, you mean as like a co-sponsor? Or?
Yeah, nice to have the whole committee, wouldn't it?
I wanna get the right committee. The House
Bill will
Human
change
Services
radically.
Probably.
the intellectual.
You won't see it for a while, it's a request. So what will happen now is.
So they would never agree with it if we did.
So what will happen is
Well, the choice is there.
recommendations will be coming back from Department of Health, Department of Aging and Department
They did a very good job of running.
when people are admitted to a forensic facility, when they have a mental health issue and they commit a crime similar to someone with an intellectual disability.
Where that
They've
we
committed a crime. What are the conditions under which?
yeah,
That's
so
bill.
we have, let me get back on track. So right now, drafted, we have a with a psychologist, scientist, individual with lived experience of intellectual disability with previous experience in criminal justice or civil commitment, family members of individuals with an intellectual disability who have experienced the justice system or been committed pursuant to Act 248, the executive director of the Department of States and Sheriffs, the Defender General, representative of the Center for Crime Victim Services. So we'll move that up to the membership list.
Yep.
Commissioner of Corrections, State Standing Program for Developmental Services, president of the ESEA. So we'll move that one.
Goes up and then
And
we add.
Office of Racial Equity.
Davis's.
I will make that. Okay. In terms of powers and duties of this group, the group shall assess the need for a forensic level of care for individuals with intellectual disability, including the extent to which a forensic facility addresses any unmet needs or gaps in resources for individuals with intellectual disabilities. If the working group determines there is a need for individuals with an intellectual disability to receive programming in a forensic facility, the specific circumstances under which an amendment committed to the custody of the commissioner would be placed in a forensic facility. Any amendments needed to the sort of Dale commitment section in Title 18, including amendments needed to ensure due process prior to and during the commitment process, regardless of whether the working group determines that a need for forensic level of care exists. The roles of Vermont Legal Aid and Ombudsman or the Disability Rights Vermont in serving individuals with intellectual disabilities who are placed in the forensic facility. Any necessary changes to the language in Title 13 regarding commitment of individuals with intellectual disability. And then in subdivision 6, line 11, investments, policies, and programmatic options for high quality community-based supports for at-risk individuals committed to the custody of the Commissioner of Dale. Under assistance, the working group has the assistance of Dale. The report is to come back on December 1st of this year to the various policy committees with findings and recommendations for legislative action, including proposed legislative language. So this is asking that group to start drafting up what the sections would look like on intellectual disability based on their conversations and decisions. We have the representative of Dale is calling the first meeting to occur by July 10th. A chair is selected at the first meeting. The majority of the membership constitutes a quorum. The working group shall cease to exist on July 1 of 2024. And we have per diems for members and for legislators, and a definition of what is meant by forensic facility, because that is no longer part of the bill since that portion was removed. And then the bill takes effect on passage.
I have a question. The working group continues until July. So what, if any, conflict is envisioned for the committees of jurisdiction and the working group going forward on recommendations? Is there any kind of a conflict there, or is there an expectation that the working group will not complete its work by December?
The conversation was leaving it open in case this body felt the need to have a group to consult with as it moved forward.
Okay.
Okay. Anything else for Katie? Since we're going to concur with further proposal of amendment, is there anything else that folks want to amend?
Not make it a study.
Right. Yeah. I think we're fine at this point. It's not, it would be nice. I think that I'm hearing from my committee in here, it would be nice not to have another study in place, but we'll deal with it together, I think.
I agree. Anybody who would like to speak who's either on Zoom or in the room right now? Karen Barber?
Thank you. Sorry, I just, I know I've spoken already, but I just kind of wanted to say one kind of general comment, which is that, you know, from DMH's perspective, I really want to echo Stuart's comments. We spent a lot of time with you all at the beginning of the session and felt like a really great bill came out of the Senate side. That's obviously the version we prefer. However, we also really firmly felt that it needed to be a joint DMH and Dale facility, that we need to stop siloing care and instead focus on providing services for a small group of individuals with complex needs that can't be provided by only one department. It seemed in the House that this was the only path forward. So that is what we will do. Our plan is to work towards implementing the vision of a of a full forensic facility and presenting concrete plans next session. I would note that as a person who facilitated unsuccessfully an 18-month working group, I hear you. We did express those concerns, but also ultimately respect the decision of the House. So we feel like our job is to work to meet the unmet needs of all Vermonters. And that's what we plan to do this summer and fall. And we look forward to working with you to implement a vision and a facility that can come in line in July of 2024.
Good, thank you.
Thank you.
I just recognize another person who should probably be on the working group. And that's the chief superior judge or designate. They're the ones making decisions in the community. Is that agreeable?
Well, it looks like I'm like talking in health and welfare, but I can't hear them.
Yeah, I can't hear health and welfare anymore.
We didn't say anything.
We didn't say anything.
I-
I'm trying to understand what your question was, Senator.
Okay, my question was, is there any objection to adding to the working group the chief superior judge or designate?
No,
Is that-
there's no,
It's the courts that end
I
up
don't have-
making decisions, and
I have no objection to that. And I'll look at my committee. Anyone have an objection to that? No, we're fine with that.
super. Yes,
For the record, Rachel Seelig, Director of the Disability Law Project at Vermont Legal Aid. We represent the approximately 25 individuals who are committed to Act 248. We did not have the opportunity to provide testimony on this bill to the Senate. And we did have the opportunity to provide testimony to the House. We have pretty significant concerns about using a facility or institution for people with intellectual disabilities. And so we are very willing to work on this working group over the summer, but given that we did not get to participate on the Senate side, I think some of the concerns that we have with using institutions for people with intellectual disabilities and returning to the days of branded training school are a good reason to slow down on the intellectual disability side of this facility and really let us think through those issues and the consequences of those issues a little bit more clearly. We were also not included in the working group that met for A2.
but in terms of comparing it with the Brandon Training School, from my perspective, these are people who have been either charged with a serious crime, found incompetent to stand trial because of the intellectual disability. And it's a total of 9 beds, and so I don't think it gets anywhere near, I think it was 300 odd beds at Brandon.
At one point, there were more than 600 people there,
600.
but an institution is an institution. And we've made a decision as a state to deinstitutionalize people with intellectual disability, and this goes in the opposite direction.
Wow.
So I understand the concerns that you all have with the changes the House Judiciary Committee made, but from the perspective of the organization that represents people on Act 248 in their annual judicial reviews, many of whom stay on Act 248 far longer than they would have been incarcerated or on probation or parole. I do think it is really well worth looking at this group of people in a way that was not looked at by the working group, that was not able to come to consensus.
Thank you for your testimony. Anybody else who would like to offer testimony? From the Judiciary Committee's perspective, I think we're done. Is anything from Health and Welfare?
No, we're fine.
Great. See you on the
Thank